Mr. Mallet, good morning. You have 10 minutes.
Thank you, Chief Justice Marshall. Good morning, and may it please the Court. I'm Thomas Merritt, representing the plaintiff, Michael L. Kettenbach. This case presents the question whether the defendants, the Board of Bar Overseers, and the Bar Council are subject to the Public Records Law, General Laws, Chapter 66, Section 10. The plaintiff contends that they are, respectively, a board and an agency of the Commonwealth within the definition of public records contained in General Laws, Chapter 7, Section 4, Clause 26. Therefore, he is entitled to inspect and copy certain documents which he has requested and which are named in pages 14 and 17 of the record appendix. The defendants are an independent board or agency of the Commonwealth. They exercise a portion of the sovereign power, a governmental function separate from, although subordinate to, this court. Thus, their status is not governed by the case of Lambert against Executive Director of the Judicial Nominating Council, upon which the defendants have relied in their brief. The Lambert case, the court said that the Judicial Nominating Council exercises no public function, exercises no part of the sovereign power, and the members of which hold no public office. And in Lambert, the court referred to its earlier advisory opinion of the justices, which appears in volume 368 of our reports. Second, the defendants possess independent regulatory authority. They're separate administrative bodies who exercise authority affecting every attorney's constitutionally protected interest, constitutionally protected property interest in the license to practice law. Their independence has been recognized by this court itself, by the Attorney General, and by the United States District Court for the District of Massachusetts. In the case of in the case of matter of Correlia, which the defendants refer to in their brief, this court referred to the Bar Council as exercising an independent prosecutorial discretion with which this court will interfere only in cases presenting extraordinary circumstances. Next, in the case of Johnson against Board of Bar Overseers, which is reported in 324 Federal Supplement 2nd, the Attorney General before the United States District Court took the position that the defendants there, as the defendants here, are independent administrative bodies. This position was adopted by the United States District Court by Chief Justice Young, who held that they are indeed independent administrative bodies and arms of the state, and therefore entitled in their own right to assert the 11th Amendment's prohibition against suits against states in the federal courts.
Mr. Mallet, how do you deal with the piece of your argument where you said, assuming that they are independent administrators or prosecutors, subject to the supervision of this court, which is obviously the judiciary? I mean, you're simply saying that that doesn't put them into the judiciary?
Your Honor, they're not in the judiciary. The judiciary consists of clerks, judges, and staff members, and judicial officers. They're separate administrative bodies within the judicial branch of government. My brother, in his brief, has overlooked that and does consider them as part of the judiciary, but indeed they are not. They're administrative bodies, and as such, they can be subject to the Public Records Law.
But does that mean, by your argument, that let's say, the administrators at the Supreme Judicial Court, the reporter of decisions or staff counsel are subject to it's only the justice's work or the clerk magistrate's work that is not subject to the Public Records Law?
Your Honor, the reporter and staff counsel don't exercise the power of the sovereign. The Board of Bar Overseers and Bar Council do exercise sovereign power with respect to a double part of the community. They exercise it throughout the Commonwealth, and they have responsibility that impinges upon a constitutionally protected property right. which the officials that you mentioned do not. I would say that the court has formed these two bodies under its supervisory power, which is articulated particularly in matter of Dissonier number 4, which is in volume 360, page 787 at 808. And this expresses the supervisory power and its origins. In exercising this power, they have established the defendants. The defendants, however, are independent of the court and can be subject to the public records law.
Well, isn't the power to license and remove licenses for the practice of law has always been this court's power, right?
Your Honor, it is this court's power, but if the court decides...
And we've simply delegated it to an agency that responds to us. Lawyers are not suspended or disbarred without the approval of this court, are they?
The Board of Bar Overseers has the power to issue admonitions. Bar Counsel can commence prosecutions. There are things that can have overwhelming impact upon individual members of the bar that repose in the defendant's discretion. Okay. The possibility that I would mention also is that the defendants do not address the fact that these are independent bodies, and they rely upon them being part of the judiciary, and thus subject to such precedents as Ottaway newspapers against the appeals court and Sanford against Boston Herald Traveler Corporation decided...
But you're suggesting that they're independent of the judiciary. Is that your argument? Even though we establish them, we oversee them, and they perform our functions.
Your Honor, they're within the judicial branch of government, but they're separate from the judiciary. They have a separate...
So where do they fit? Are they part of the legislature or part of the executive? Or are they some kind of free-floating space debris that fits into none of the categories of government?
Your Honor, they are within the judicial branch, as are certain other agencies that exercise the sovereign power or discharge its sovereign responsibility, such as the Mental Health Legal Advisors Committee or the Committee for Public Counsel Services. Those two agencies have legislative origin. However, legislative origin is not necessary. In state Massachusetts Bay Transportation Authority Retirement Board against State Ethics Commission, which is reported in volume 414.
But when you take those other ones, you're talking about mental health, legal advisors, so forth. This one's different because it relates to the organic structure of the judicial system that's existed since it began, namely, including common law power, to discipline, license, and so forth, lawyers.
Your Honor, the power has always been there, and at an earlier time it was exercised by the court itself.
Correct. So now the court has delegated it because of the massiveness of the size of the bar and so forth, resources, time, efficiency, to the BBO. Otherwise, we'd be doing it ourselves. So they really are part of us.
Your Honor, the court theoretically could exercise these powers itself. Having decided to delegate it to these two agencies, the agencies are separate from the court and are subject to the public records law we submit. They do not have to have statutory origin. In the Massachusetts Bay Transportation Authority case that I mentioned, this court acknowledged that a public agency can have origin in a regulation or in a executive order. Nothing in Lambert turned upon the Judicial Nominating Commission having been originated by executive order. I submit that this is a case where it was done by this court under the exercise of the acknowledged rulemaking power in furtherance of the supervisory power derived from statute and common law and the Constitution, and which is summarized in matter of Dissonier number 4. My brother has mentioned that there will be certain statutory redundancies if the court adopts the position that I am advocating. That is not the case. They rely on three introductory phrases in General Laws, Chapter 7, Section 4, Clause 26. And the first, in our view, simply refers to agencies exercising discretion throughout the Commonwealth. The second is to our cities and towns and counties. The third is to public agencies created by the General Court, which have responsibilities local in nature, such as, and there are some of them around, like the Massachusetts University Building Authority or the Lowell Technological Institute Building Authority. Therefore, these clauses all have meaning and would not be redundant should the court adopt the position that we are wishing to advance.
Thank you, Mr. Mayor.
Thank you very much, Your Honor.
Council certain duties that it would otherwise have direct responsibility for. And although one might say that the activities of the Board of Bar Overseers and Bar Council have a public purpose, nevertheless, they are unlike the entities established by the legislature to regulate other professions in Massachusetts. There's a distinction to be drawn between the regulation of practice of law and the regulation of practice of medicine, because it is this court that has retained exclusive jurisdiction for the former. And to construe the public records law as extending to the activities of Board of Bar Overseers threatens a constitutional separation of powers dilemma, because it could not be proper for the legislature to dictate to the judiciary how it will investigate allegations of wrongdoing by officers of the court.
But couldn't the legislature make the Public Records Act applicable to the judiciary, or are you suggesting not?
Well, I am suggesting that it would raise a difficult separation of powers issue.
But it's applicable to the to executive agencies, isn't it?
It is.
But not to the governor himself?
Not to the governor himself, not to the legislature
Itself.
and not to the judiciary. And if the legislature were to insist that all records held by the judiciary be public and that all activities by Office of Bar Counsel be done in public and the public have access to the records, I would submit that that would be invading the exclusive jurisdiction of the judiciary to administer justice and to discipline individuals who practice law in Massachusetts, which is not part of the province of the legislature. Under this court's rule, it's of course necessary to maintain the confidentiality of the records in question in this case. Prosecutors enjoy broad discretion whether to investigate and prosecute or not, and to keep their deliberations confidential. And that confidentiality is of critical importance to these investigators and prosecutors if they hope to enjoy material cooperation from third-party witnesses. Mr. Kettenbach has not justified his demand for this breach of confidentiality. He doesn't need defendants' records, and in fact he's merely speculating that the requested documents even exist in order to petition the legislature or his fellow citizens. There doesn't seem to be any justification.
I'm sorry, to petition them in what sense?
Well, in his brief, Mr. Kettenbach says that he wishes to share information with the legislature about former Judge Maria Lopez's actions in petitioning the legislature to commence a bill of impeachment against her.
But she's no longer, well, you know that.
He could be seeking to disqualify her from holding any public office.
Oh, is that it?
Yes.
If we're impeached, we can't hold any other public office? Is that?
Well, I believe there is a procedure by which one could be, in extreme cases, disqualified from holding public office.
Have to be careful.
So, but of course, Judge Lopez, former Judge Lopez, has assumed inactive status. She is not practicing law in Massachusetts. She is engaged in a...
Excuse me, Mr. Quinn, maybe I should have asked Mr. Kettenbach this. The practice of law, are you suggesting that the whole public office includes the practice of law?
No.
No. In other words,
she runs for state rep or something. Is that what you're thinking?
Well, I was thinking of the law review article that he cited discussing this issue on the federal level, where a federal judge who was removed from the bench, Congress could have
that's the guy
impeached
down-
him
Guy
and
down in Florida?
Alcee Hastings and prevented him from being elected to Congress, but in fact, Congress did not do that, and he now sits in Congress.
It's a very interesting question, and here's the question. Is assuming for purposes of discussion only that there was some kind of arrangement made with the Judicial Conduct Commission, I assume, that she would agree to resign and she would agree not to practice, she would become inactive at the practice of law. It strikes me that the real challenge is to the agreement to resign.
And
Correct.
that would implicate records of the Commission on Judicial Conduct, which by statute are
But
confidential.
they're not a party to this, am I missing?
They're not a party to it.
But that's what I'm saying. You can go to it's part, if that's where the complaint lies, it's the fact that she resigned and wasn't charged, correct?
That there wasn't a further effort by Office of Bar Counsel to have Ms. Lopez disbarred.
Okay.
I think that's the issue. But of course, it's entirely speculative as to...
But that wouldn't impact her right to hold public office.
Perhaps not. Perhaps not.
Thank you, Mr. Quinnan.
Thank you.